Welcome to the Great Trials Podcast, where you get a behind-the-scenes look at America's greatest trials with the trial lawyers who tried them.
If I can't explain the case to my mom in 30 minutes, right, and her understand it, then I'm doing something wrong.
Please rise. Court is now in session.
All right. Well, welcome to the Great Trials Podcast. This is Steve Lowry along with Yvonne Godfrey. Yvonne, how are you doing this afternoon?
I'm good. I'm excited. We have a fun case to talk about today.
A very fun case and a great guest. But I was going to mention something, and we'll have our guests talk about this too, Natalie. But I actually got my first day in court yesterday. I was actually in a courtroom, and it's been more than a year since I've been in an actual courtroom. So
I didn't realize. So that was in person.
It was in person. Yep.
In Chatham?
In Chatham, yep. They had all the glass up, so like the judge sits behind glass, the witness is behind glass, and all that kind of stuff. But otherwise it was regular old courtroom. I mean, it was nice.
Do you take your mask off when it's your turn to speak, or does everybody keep them on?
So interestingly, the judge didn't have much guidance on what we should do. He basically said, I've been vaccinated, so you all do whatever you want. And so everybody left their mask on except if they were talking. And then when they talked, they took their mask off.
Gotcha. That's classic Chatham County.
Yeah, exactly.
It's our new normal, I guess, for a little while. Anyway,
that's right.
I'll be curious to see how long this lasts. I've been vaccinated, and as vaccinations increase, I'll be curious to see if this lasts just this year or how long we'll do this for.
Right, exactly. And I've heard about booster shots being out there, and but at least it's exciting for all of us to we've been hearing a lot about Zoom hearings. We've heard about some Zoom trials. We've had some guests talk about that, but there is something about going in person to court that's just different. So it's exciting that it's happening. Basically, a year later,
they were doing jury trials. They were doing a murder trial while we were there. So,
really?
They're trying to get back to it.
Did you get to peek in at anything? Like, how are they handling? Where's the jury sitting?
I did not look in on where they were doing the murder trial, except that they were hurting is the wrong word, but having the jurors walk through the halls and taking them to different rooms.
Yeah.
So that's how I was like, are you guys doing a jury trial here? And they're like, yeah, we're doing a murder trial right now.
Wow.
So that was my extent of it.
Exciting stuff.
Well, something for sure. I think some parts of it will be interesting because I don't foresee, at least for us, going back to how we did things before in every way. Because I think the days of us feeling the need to travel to every single deposition is
right.
Just, from a cost standpoint now with the technology that we've all learned, I think that part is here to stay.
I agree. I agree. Virtual depositions, in my opinion, work pretty well. The technology's good. I kind of prefer them because of, one, they force you to get organized ahead of time. They, when you're sitting in your conference room or wherever you're sitting, you spread stuff out the way you want it and you don't have to worry about anybody else looking at it. So I absolutely agree. And from a cost standpoint, it definitely reduces cost for cases.
For sure.
Well, so should we go ahead and introduce our guest?
I think, because she's been talking, but we haven't told anybody who she is. This is just a mystery guest. So we're going to let our listeners guess who our guest is. No,
we're just not going to tell you.
Right, exactly.
No, I'm very excited to have this guest, and we canceled on her. We had to cancel on her twice for unexpected developments in our cases, and she was so cool to reschedule with us. And we were looking forward to talking to her and talking about her case for a while. So I'm glad it's finally happening. Our guest is Natalie Woodward. She is founding partner at Shamp Jordan Woodward, and you can look her up at sjwtriallaw.com. And one of the things I think this is right at the beginning of Natalie's bio, if you go and look her up, but it is so true, is that it says anyone who meets Natalie feels like they've known her their entire life. Yeah. And I feel like that's so true for Natalie. She's just so easy to talk to and just like one of those people that's just really fun to be around. So Natalie, thank you for being on with us today.
Thank you for having me. I've been a fan for a while. I've been listening, and this is so cool.
Well, and we should mention that, so we had your partner on as one of our first guests, I think more than 2 years ago now. We had Laura Shamp on, and she talked about one of her tobacco cases, and those are always fun to talk about.
Yeah, I remember. I listened to that. That was, so those are cool. She has not done any of those in a while, but for several years there, she was doing a lot of those. So,
yeah. Well, we have a treat today because your case, I think, we definitely haven't talked about a case like this just because some of these facts are really crazy. But before we get into the case, I want to tell our listeners who don't have the pleasure of knowing you a little bit more about you. Natalie has tons of experience in personal injury, product liability, medical malpractice, false arrest, and malicious prosecution. And that's what we're going to talk about today. She's gotten terrific results in those areas, including the case that we're going to talk about. Natalie is a double dog, which everybody in Georgia, or most people in Georgia, know what that means. But for our listeners, for that one listener we have like in Australia and other places.
I think we're actually up to 3 listeners in Australia.
3 listeners in Australia. So for our Australian fans, that means that Natalie went to University of Georgia for undergrad and for law school. And that's actually how I met Natalie. She was doing, she was an alum judging a moot court thing, which Steve, I don't know when we're going to post our bonus episode about law school, but listen to that episode if you want to know more about moot court. But
yes, we should tell everybody that we are coming out with a bonus podcast where we talk to our producer Raz about whether or not he's going to go to law school, and I think he's leaning towards it. So
good.
It was a fun conversation, so we should be posting that soon. But anyway, as Natalie's she's basically one of those people that juggles a million different things and you wonder how she does it. She's on the executive committee for the Georgia Trial Lawyers Association. She's on in the Atlanta Trial Lawyers Society. She serves on nonprofit boards. She just does a ton. She was named one of the best young lawyers in Georgia by Atlanta Magazine, which is a big deal. And the thing she's probably the most proud of is that she's also a super mom. So,
I am. Yes, I am. I have a 6-year-old little boy, and he is awesome. He told me he wanted to be a lawyer last week, so that was really cool.
That is awesome.
Yeah,
that
was fun. Yeah, I'm gonna try to talk him out of that, but yeah, that was good.
Yeah, we'll see if that lasts. I've got my girls were similar when they were younger. Now that they're teenagers, they're not. I don't think they're so sure they want to be lawyers.
Yeah.
Oh, well, we'll work on that. Exactly. I'm aiming for a swimmer. I'm hoping. Yeah, I'm trying to make the next Michael Phelps. So we'll see how it goes.
Good idea. And then he can do whatever he wants after that.
Yeah, after the Olympics, he can do what he wants. Yes.
Yeah. Well, so let's talk about the case, Natalie, that you brought us to talk about. And this is going to be, like I said, it's really fun facts for us and different than a lot of the cases that we've talked about.
And I think we should tell our listeners, if I read right, Natalie, this was your very first case as a lead trial lawyer.
It was. Nice. My Corey Stern and I had both been working at 2 different law firms. We had graduated law school a year apart and had been friends since law school. And he had been working at Pope McGlamory, a big, awesome plaintiff's firm. And I had been doing medical malpractice defense with Scott Commander and Ted Pound and Scott Mayfield. And we were 30 and 31 respectively when we started our firm, which now sounds ludicrous. But, but yeah. And so this was the first trial that I had after we had started the firm that I was lead on. And and it was against, I think one of the things that made it, looking back now, poignant was that it was the opposing attorneys were my ex-bosses. My first job out of law school. Yeah, so my first job out of law school had been with Brinson, Askew, and Berry in Rome, and they ended up representing the defendants in this case. So that was unique.
I'm sure.
But
yeah, so that was kind of cool about it also.
Wow. So lots of dynamics happening in this case.
Yes.
So the case is called Robert Richard Lucas versus City of Braswell. and others. It was tried in 2003 in the Northern District of Georgia. And I'm sure this will come up in our conversation, but as we've talked about before on the show, trying a case in federal court can be a whole different ball of wax than in state court. Everything from what you have to provide before trial to how voir dire is going to work. So we'll talk about that. But first, I'll tell the listeners a little bit about the case.
I think I should say you might have just mistakenly said 2003. I think it was 2010 when it was tried.
Oh, my bad.
That's right.
Yeah.
I did say
it's not a big deal.
I did say 2003 because I wrote 2003. I don't know where that came from or why. 2010, my bad. Especially because the next thing I was about to say would not make sense, which was in 2007.
Right. Yeah, exactly. Everything happened in 2007, but we somehow tried this 4 years earlier.
We knew it. So in 2007, Robert Richard Lucas, he was the chief of police for the city of Braswell, which for people who don't know is pretty small. It's about 3 square miles. We'll talk a little bit about the dynamics of what was happening.
Well, and I saw you somewhere in I think it was your complaint, there was 1 police officer for every 16 people or something like that.
Something to that effect.
Yeah.
It was a very small city, and it had really been controlled in large part by this particular family that owned the one bar and owned the one gas station and kind of controlled but a lot of the city, both from a business standpoint and from government standpoint, both. So, which is not uncommon in rural Georgia, especially in the 70s and 80s, and it's less common now. There are a lot of small cities. For any folks who took Centel at UGA and learned about municipal corporations,
right.
There are some unique parts of city and county law in Georgia.
Right. And so that's one of the really interesting elements of this case was that as Natalie mentioned, the mayor, Richard Fennell, and then the city manager, Alan Fennell, were kind of the 2 major individuals involved in this case. 2 of the major individuals in the city of Braswell kind of controlling what was going on, and our father and son. City manager is the father, right? And then the mayor's his son.
Yeah.
Right.
Okay.
Yes.
Okay.
And under the requirements, in order to have a bar, you have to have a police department that is at least operating while the bar is open. So that's why the police department had to at least be operating and have officers. The county would normally respond to normal 911 calls, but you had to have, if you're in the city limits with a bar, you got to have a police department in that city limits also.
Right. And another just interesting fact, I think, is that this was a part-time police department and they worked from Thursday through Saturday, which were the same hours the bar was open.
There you go.
Yeah.
Gotcha. So that sort of background makes what I'm about to say make a lot more sense, which is that Robert, who was chief of police at that time, had basically told the mayor, we need more vehicles. And so he wanted to purchase some used Crown Vics for the police department. And the mayor essentially told him that they didn't have enough money for both vehicles right now. And so what the mayor did was he gave Robert $1,000 for one of the vehicles and told him, if you pay for the other one personally, I'll reimburse you when some tax money comes in. Right. So Robert goes and gets the 2 Crown Victorias, including buying the one with his own money. And then he pays his own money to get the city of Braswell lettering and everything on it and puts it into service for the police department. And then he's waiting and he's not getting reimbursed for what he's paying for this vehicle that the police department is using. And then, Natalie, I wasn't sure which happened first. It sounded like maybe the mayor, the then mayor, lost his election, so a new mayor was going to be sworn in, and then Robert asked the mayor, like, "Hey, where's my money? And
Right.
And the mayor essentially and the city manager told Robert he wasn't getting reimbursed, that it was a non-reimbursable donation to the city, this vehicle.
Yes. So they decided at that point that their position was that he had donated the car. And he said, no, that is not accurate. And the reason why he'd gone to them is, as you guys know, oftentimes when the new mayor comes in, the mayor can pick who the chief of police is going to be.
Right. So he might be out of a job.
So he knew he was about to be gone too, since there's going to be a new mayor. So he's going back and saying, hey, can you pay me for the vehicle? And they said, no, you've donated that. And that's where the things go off the rails.
Well, and one of the things we should mention is that the title was in his name, though. The title of the vehicle was in his name. Yes. And that becomes a big point.
Yes, it becomes important later. But yeah, so when he had done it, he had the good sense that since he was purchasing it, he was going to have the title in his name, at least until he got reimbursed.
Right. Yeah. He figured out how to come up with the funds to buy it, bought in it himself. And so the title at this point is in his name. So he's told he's not going to get paid back. He's like, okay, well, I've got the title to this vehicle that I paid for. And so he resigns as chief of police and he takes the vehicle and parks it at his house.
Well, he repossessed it from another police officer, right?
Right.
Okay. I didn't know if you were saying, okay.
So a friend of his,
tell the story.
A friend of his who was actually using the vehicle, who was also in the police department, he goes to him and says, hey, I need the police car, because they were taking them home. And what a lot of these guys would do, and the reason why they did this is that these were not their main jobs. They would do these part-time police department jobs in order to maintain their post-certification. And then by having their post-certification, they could then have private security jobs. And so their private security jobs, or, if they were truck drivers on the side, whatever, it doesn't hurt to have a badge. There's various reasons why them having their post-certification and then doing these private security jobs. I think Mr. Lucas did his for Georgia Power. That would be where they would make the bulk of their money, their salary, but it depended on them being post-certified and actually employed by a police department in order to maintain that certification.
Got it. Okay. All right. So that's interesting, because I didn't realize, I was kind of like, what are these guys doing, otherwise? But that makes sense. So Robert has resigned from chief of police. He gets the vehicle back. He parks it at his house, and then I guess at that point, the acting police chief, Mr. Williams, kind of with direction from the Fennells, the mayor and the city manager, gets a replacement title for the vehicle under false pretenses. He essentially lies and says that that Robert, Natalie's client, lost the title and gets a new title issued in the city of Braswell's name for the vehicle.
Right. And he has to go to the mayor of Powder Springs, where they had bought the car from, and where he works part-time as well, and says, right, hey, mayor, we've lost this title. We need a replacement title for this vehicle. She doesn't question it, says, okay, great, no problem, gives him the replacement title, and then he takes that to the magistrate judge as his basis to swear out the warrant for stolen vehicle.
Yes.
So and by the way, I could see, I saw how Natalie described that in the opening statement, and I could just picture her saying, where she's like, "Oh shucks, Mayor, we lost the title. Can we get another one?" Yvonne, that the practice of law since the pandemic has started has completely changed.
Completely changed. A lot more pajamas involved for me.
Yes. A lot more working from the computer. Yes. And only getting dressed from the waist up. But who has helped that change and that transition immensely in our practice and can help everybody else in theirs is Legal Technology Services.
That's right. Being good at doing things virtually, at doing things through Zoom, through video conference, online, it's more important now than ever.
I'll say Zoom or WebEx or whatever you use now, Legal Technology Services has completely changed how they do things in order to get you organized, looking good. Our depositions, our hearings, our mediations have all changed. And a big part of that is because we do them all virtually, and we're doing them with the help of Legal Technology Services. So they get our exhibits in order, and you call up the exhibits by number. They'll highlight them, they'll enlarge them, they'll do whatever they want. And it actually flows really well. I do have to say, I think my depositions are more organized now than they were before the pandemic, because I used to just walk in with like a giant box of documents, and then I'd pull out the documents and go through them. And now I'm much more organized because of Legal Technology Services.
Yeah, and I mean LTS. I'm gonna call them LTS because we're on a first name basis. My favorite thing about them is that we work with them a lot. Their staff is really highly trained, and you can always count on them to represent you well. Whether they're doing your trial technology when we have in-person trials one day, or if they're handling your depositions, or they're doing settlement videos, other kinds of videos documenting stuff for you. You can always count on them to conduct themselves well. Clients like them, judges like them, courts like them, lawyers like them.
Yeah, the one thing that I have to say is when we're in trial, while I think we do pretty good in front of juries and hopefully they like us, they always like our trial techs, whether it's Bob, Taylor, Quentin, David, Liz, just any one of the people over there. They're all fantastic. And of course, Melanie, who runs the ship over there. But they do more than just exhibits. They do day in the life videos. They do settlement documentaries. They do demonstratives, and everything they do is just excellent. And you can look them up at ltsatlanta.com. And I can say that if you call them and tell them that you heard about them on the Great Trials podcast, then you get 10% off of your first service. So look them up at ltsatlanta.com. And I do want to say, even though they're based in Georgia, they do work nationwide. And I know they've done trials all over the country. But look them up at ltsatlanta.com.
You can see this going down, especially in a small town, right? That it's just kind of, you take folks' word for things and you just get this stuff done, especially when you're doing stuff for the city. It's kind of crazy. So then they get this new title that is not right. And meanwhile, Robert's still got the actual correct title. It has not been lost. But then meanwhile, so the Fennells and Mr. Williams, they run with it and they start pursuing a criminal prosecution against Robert. So they have him arrested, which is already crazy. But then as Natalie, pointed out to the jury and in the pleadings of this case, he gets arrested and he gets put in jail in a holding cell with people who likely know that he is in law enforcement or was very recently in law enforcement. That's an additional sort of stressful situation for him. I got to imagine, Natalie, like, did you get the sense of whether, I'm sure you did, whether, what that was like for him? Was he scared that people knew, or did people actually know?
Yeah, because, the way he described it was he literally was put in a tank, with folks who he had previously arrested before. And so you're in this, sort of general holding cell. And that was one of the kind of odd, you get feelings about cases, right? We all do, about certain things where it's hard to put a money value on. You go, okay, well, it was only 8 hours, or it was only 10 hours, or it was only 2 days or 3 days, or whatever the timeline is for various cases I've had. But, then there's this is a guy who's upstanding, police chief, and he's getting arrested in front of his neighbors, in front of his kids for something that's, a theft related accusation, taken to the police department, booked in, fingerprinted, mugshot, and put in, a holding cell with folks who he's actually arrested before. So the stress of all of that, even under a relatively short amount of time, I think is part of what made it something that I was interested in taking.
Yeah.
Right.
Yeah. Right. You hear about these facts and it's hard to imagine what it would be like for him, because I can't really imagine arresting somebody. But just because I've never been in that situation. But it's clear from what he goes through, especially when you think about how all this gets started, because he's trying to get equipment that the police department needs. And this is how he's paid back for it. So anyway, to sort of wrap kind of the things up that led up to the case. So he eventually makes bail, and the criminal prosecution, the judge finds that there was no probable cause for the arrest warrant. Once, Robert's basically able to produce that he's got the title for the car. Anyway, so that all gets terminated in his favor. After that, and I'm interested in hearing more about this from Natalie, there's the Fennells come up with a check that was purportedly used to reimburse Robert. And it's a personal check written to Robert by the mayor, but then on the face of the check, it is at least supposed to look like then Robert endorsed it back to the mayor, and then the mayor supposedly cashed it and gave Robert $3,000.
Right.
Yeah.
So that was, and you guys know this because y'all both had these sort of beginning parts of your career where you're getting calls. I mean, I'm from Marietta, from Powder Springs. Every relative I have is within a 25-mile radius, right? So everybody I went to high school with, and lots of folks I went to college, and so you end up fielding a lot of calls from folks who will call you about various things. And so when I first got the call about this case, it was right before he had gotten arrested, when the fear was that he was going to be arrested because there was the warrant out for him. And of course, when you first hear this stuff, you're like, well, it seems like some kind of misunderstanding. It looks like something y'all can work out.
Right.
Surely you can. And then the next call is, oh, he's been arrested. And so we actually helped effectuate the charges getting dropped. Because as you know, in the criminal or in the false arrest world, you don't have a false arrest case if you plead guilty, or if you're found guilty, or if you plead guilty to anything. Right. And so the charges had to be dismissed in order for there to be even a possibility of anything later on. So we actually worked on that part first. And so when the decision to, let's file, because otherwise his arrest was going to stay on his record. Mm-hmm. The charges had been dismissed, but they had not expunged his record. So he was going to have an arrest record unless something was done to counter that. And so that arrest in and of itself, despite the fact that there was a decline to prosecute, the arrest was going to keep him from being able to do future jobs as a police department anywhere else. He would have that arrest on his record. And that would then mean no post-certification, all these security jobs, those kind of things. So it was going to have a domino effect on his life that really made it make sense. It wasn't just, hey, I'm mad that this happened to me. This was going to follow him, but for him doing something about it.
Gotcha. Well, I sure would have been mad if I was him. And he's very fortunate that you saw it the same way, and that you got involved early enough to kind of preserve the false arrest issue and take his case. And so Natalie pursued claims under Section 1983 for the false arrest, malicious and retaliatory prosecution. And in 2010, this, as I mentioned, this was the Northern District of Georgia. This was up in Rome, Georgia. Returned a verdict in Robert's favor, awarding $560,000 in compensatory damages and $440,000 in punitive damages, for a total award of $1 million, which is huge. Such a great result. And for those who, we'll talk a little bit about this, Natalie, because I like how you handled this in your argument, but in especially in Rome, Georgia, that's not necessarily a jury pool where you think they're going to come up with a big verdict. So really great result. There's so much to talk about. But one of the things that I want I think would be really useful, because we don't talk a lot about a lot of cases like this on the podcast, is if you can just talk a little bit about when you're approaching 1983 claims in general, knowing that you're going to end up in federal court, and just kind of how you approach those and the unique challenges that they present.
Well, the reason why they are so hard is because of qualified immunity. And that's really, that explains it. And what that means is that it's not enough to just show that someone made a mistake, that someone that was arrested who shouldn't have been arrested. Hindsight is such that if the officer who swore out the warrant to obtain the warrant, if they were mistaken, but reasonably mistaken, that in and of itself, no matter how wrong it was, how big a mistake it was, if it was a reasonable, good faith mistake, they are always going to be get out on qualified immunity. It's the classic scenario of, you're chasing officers chasing somebody who they just saw commit a crime, and the person turns around and the officer thinks it's a gun and really it's a cell phone, and somebody gets shot. Well, was the mistake reasonable in the moment?
Right.
And so what we're seeing in the news a lot right now, even today, we're waiting on a jury verdict in the George Floyd case, is, this outpouring of frustration from cases where it wasn't a innocent mistake. It was an intentional act meant to harm. And even in the police context, a intentional act to harm is still going to get immunity if it was a reasonable response to the situation. So what makes it so hard is because you literally have to prove that they acted with malice, that they knew that they were doing something wrong at the time. And the reason why this case was able to even get to a jury was because we were able to show that when he went and swore out the warrant, when he did the affidavit, that he knew he was lying when he said, this vehicle's ours.
Right.
Right. He knew that. So because he knew that and knowingly gave false information to the magistrate judge, that was enough to get us past qualified immunity. And that is a rare occurrence where you have evidence of knowing fault on the part, knowledge of the bad action on the part of the person who is causing the arrest to happen.
Right.
But that's why 1983 was so hard.
Yeah. I was wondering when you got a sense in this case of that you'd be able to overcome qualified immunity, and also how you were able to gather the evidence to do it. I mean, did you have to rely basically on the depositions of these folks, or did you have any good emails or anything in discovery?
Yeah. So, interesting thing about that. So we did not take a single deposition in this case, not a single deposition. We filed and relied on everything from the documents that we had. And so I think that we had an affidavit from the mayor who he'd gotten the replacement title from, right? That he had gone to her and said it's lost.
Okay.
Right. Well, he then turns around and goes straight to the magistrate judge, and we have that affidavit that he filled out at the magistrate judge where he's saying this is a stolen vehicle.
Right.
Well, if you just said two separate things just in those documents, that is in and of itself enough for that. In this case, it was enough to show, both can't be true, right? If he's just saying, it's lost, no problem, we just need a replacement title to the mayor, and then taking that immediately over to the magistrate judge as evidence of your ownership, evidence that the city owned the vehicle so that they can swear out a stolen vehicle for it, that was enough to get us past that. But that's just that was a unique circumstances. And it's funny because every single one of the false arrest cases I've had have had some element of that, where you're really not relying simply on the depositions. You almost need something else ideally, especially when you're in the front end of the case. You don't know what they're going to say.
Right, right. So that blows my mind, because that means that you showed up to this trial not ever having deposed the defendants.
We had not. And so this goes to why this is interesting, because I really think that because we were new and because we really thought, oh, they're going to see, how are they going to, they're going to see this is clear, that the lawyers are going to see, there's no question, this shouldn't have happened. Mm-hmm. We didn't feel like it was really a real dispute that, hey, he got arrested and he shouldn't have. Oh, at some point they'll make us an offer. He's a reasonable guy. Surely we're never going to take this to trial. And when they called and finally said, hey, there's no insurance. There's no, we love you, Nat, and everything. These are my ex-bosses saying this is real sweet, but no insurance. And my position was, okay, well, I'm going to try it anyway.
Right.
and because I had individual named folks as the defendants, and those individuals have assets.
Right.
And I have never since then, ever, I don't think, had a case where I knowingly proceeded against defendants who I knew were at least proposing that there was no insurance and it would all be personal assets. So that's, I think, the first and last time I've done that.
Gotcha.
One of the things I wanted to ask you about is, so he issues this warrant, which is to me is a little bit strange. Just that fact. I mean, obviously the whole thing is strange because he's making this up, but that you have the complainant, like the city of Braswell is essentially the complainant here, and they're the ones also issuing the warrant. Usually you'd think you'd go to a different police agency and you'd say, hey, look, this guy stole our car. Can you investigate it? And then, and then they decide whether or not to swear out a warrant, which didn't happen here.
Well, they got it from the counties. They went to a different county. They went to the Paulding County magistrate judge.
Okay.
And swore out the warrant to that magistrate judge. And that magistrate judge is who gave them the arrest warrant. Okay. That's why the criminal case was pending in Paulding County, was because the Paulding County magistrate judge had issued the arrest warrant. And then, as you guys know, once there's an arrest warrant, anybody can go and pick them up wherever they are. So they then, go and pick him up at his house in Rockmart and arrest him there, bring him to Paulding County. And he's in the Paulding County jail, which is the, one county over from where he had been police officer. And so that's why, there were folks in the jail there, a much larger jail that he's come across before.
Well, one of the interesting facts is that when he hears that the warrant is out there, he goes to Paulding County to the police and says, hey, look, I know there's a warrant out for me for this stolen vehicle, but here's my title. And then Paulding County basically calls up Chief Williams and says, what's the deal here? We're not going to arrest this guy because he's got title. And then he somehow, and it sounds like it was Floyd County that actually picked him up and actually arrested him. And was there ever any thought to pursue any action against Floyd County?
No, because, actually that's not true. We did think about that. And what I learned is that, it all goes back to the mindset of the officer who's acting. And so the first officer, the Paulding County officer, who said, I'm not going to carry out this warrant for this arrest because this looks like it doesn't line up to me. Then they go down the line and find someone else and they say, hey, here's an arrest warrant, go arrest him. And that guy that officer doesn't know the backstory. So we weren't going to be able to prove that that person who actually put him in handcuffs knew that he was doing anything wrong. Right.
I mean, basically he sees a warrant. It's to him, at least it's a valid warrant. So he goes and he executes it.
Right.
Yeah.
So that was why, which allowed us to keep it streamlined, and I think made it easier because, especially up in that area of the world or any area of the world, you don't like to sue the police.
Right.
And any arguments that we could have made or potentially would have made about, oh, well, they should have done more to check the validity of the warrant or something to that effect, I thought was just going to muddy the waters and make things more complicated for everybody. So we decided not to do that.
So Yvonne, the internet is getting more and more crowded, especially ever since the pandemic, and it's getting harder and harder to get noticed online. And you can have all the great verdicts in the world, but if nobody knows about them, then they're not going to come and hire your law firm. So you need to find a company like Digital Law Marketing.
That's right. It turns out that what you put on the internet is no good if people can't find it. And Steve, we've talked about this, but now that I finally know what SEO is, which is search engine optimization, it's really important that your firm's site is maximizing the hits that it's going to get. And something that Digital Law Marketing is doing that's really cool right now is they're offering free SEO audits for law firm campaigns. So that's something our listeners should take advantage of.
Yeah, because it's hard to get around the internet and know how to make yourself visible without having somebody help you. And they are the experts in this. And not only will they help you design your website if you need to, they'll do your content marketing, they'll do your search engine optimization, as Yvonne just said, they'll do your pay-per-click marketing, social media marketing, and they also will offer full management on Google's new local service ads, which we just learned about and are trying to get into, but it's another way that you can put yourself out there and get people to know who you are. And Digital Law Marketing is great at it.
Exactly. And, one of the things I think is cool is that you work with them and they really make you feel like they know your firm and they know you, and that they help you with your web presence so that it feels individual. It doesn't feel cookie cutter. It feels like they know the people at your firm and they get what you're trying to accomplish.
Yeah, it's not like they already have a website done and just give you one that's already been done, but they will spend time with you, get to know your personality, put your personality into the website, and you should go visit them at digitallawmarketing.com. That's digitallawmarketing.com.
Tell them we sent you. So Natalie, you're approaching this case and then, and so you've got to try in the Northern District of Georgia, federal court, way more rules. You sent us your consolidated pretrial order or whatever they call it in federal court. And, it's way more elaborate. I mean, it looked like y'all had to include your voir dire questions that you wanted and just everything. So, and you're approaching this meanwhile, obviously having seen through your experience, knowing a good bit about trials, but do you recall, I guess, how you approached voir dire in this case, or what you were even able to really strategically do with it?
Well, the first thing that I did once I realized that we were going to try it for sure.
Yeah.
Is that I called, who is now one of my best friends, but was at the time a total stranger to me, Bill Atkins, who is well-versed in constitutional law cases. And I said, hey, you don't know me, but I have a trial in about a month and I want you to come try it with me. And he says, after he realizes that no one's pulling a joke on him, he says, okay. So he looks at everything. And so what was great about that is that Judge Murphy, who was the judge on the case, is revered and amazing man who actually swore me in when I was right out of law school, when I was working up in Rome. Tons of experience, and no nonsense at all. And the last thing that I wanted to do was to take my inexperience at the time and make anyone's life harder. And so it was a lot of learning in a very short amount of time. That's what I think.
Yeah.
And as far as voir dire goes, and you guys may not remember this is right around the Tea Party movement time in politics. Mm-hmm. And, with federal court, you're going to be pulling jurors from multiple counties. Mm-hmm. And so, the idea, really the theme that I jumped on and tried to stay throughout was that this idea of government overreach, that this was the government versus the individual, and this idea of the brazen aspect of there not being the right kind of safeguards in place, and that ultimately a jury is what the safeguards are that exist for us. Yeah. And making that the theme because you can imagine this jury visually was about the worst jury you could ever imagine. I mean, these are all conservative folks who, law-abiding, hardworking, wonderful people who are everybody probably had a shotgun in their closet, and this was a group of folks though who I think took that same jury service very seriously.
Yeah. Well, and I think you set it up really well for them, in your opening, talking about just like, look, these are the rules. And when you're a government actor or whatever, it doesn't matter if you're up in New York or if you're what you do, there's certain things that you can't do. And so, you kind of set up that sort of rule and that kind of government outreach thing. But then I also I alluded to this earlier. I think you did this in your closing. You just talked about, people I think it's okay for people to be scared of juries. Like, people aren't scared of juries anymore. And I think it's okay to be scared of juries. And I just liked how I thought it was just very brave how you put it, I guess, because you managed to not encourage them to get angry or anything, but to sort of remind them that they could do something that would have real consequences.
It's funny to go back and look at these closing arguments and open arguments years after the fact, because I hadn't read it, obviously, since I don't think I'd ever read the transcript of the closing. So I went back and looked at it. And, I was trying to find, I can't remember where exactly, I know it came out in the trial at some point, but there was this idea of, all of these bureaucracies exist, the FAA and the SEC and, all of these things that we pay taxes for. And the point of that is to regulate and keep industries and keep government actors from going too far in infringing on our rights. And that a lot of times we actually are paying tax money for these bureaucratic organizations when if jurors and juries hit with a big enough stick when it was necessary, that those bureaucracies wouldn't be needed.
Right.
But we have to have them because literally, how much does Delta spend on peanuts, right, in a given year when you're trying to get folks to give a big enough verdict that it's going to reverberate and actually have true effect? You're talking about more money than all of them and all of us will make in a lifetime sometimes, right? So how do you get them to give that number and understand that they have to hit with a stick that meets the size of the behemoth of whatever it is? Mm-hmm. And that, I think, is hard. And we all struggle with that, right? How do you make something really, folks go, ooh, wait, this was big enough that we're all going to listen now. And we tried to stick with that if they would do what they needed to do, that this would have ramifications beyond just this case. And I think we made at some point, there was I compared that Manhattan's only 22 square miles, right? It wasn't that much bigger. And so, but the same rules apply everywhere.
Yeah. So one question I had, and you did bring this up in your opening, and I'm wondering if you ever really did get to the bottom of it, which is, basically, you've got this police officer, the chief Lucas, buying a vehicle for $1,500, and then just wanting his money back, and the city saying, no, we're not going to give you the money back. What made the Fennells and Williams take this extra step of saying, just because we're in this dispute over $1,500, we're going to take out the extra step to try and convict this man of felony car theft? It seemed like there must have been some sort of backstory that we're just not seeing, or not maybe.
That was my thing always. I said, it still doesn't make sense. I see it's happening. And that was, one thing Yvonne brought up a second ago about the check is that we're all the way into the case. We're about 2 weeks before the trial. And Mark Webb, someone who had also been one of my superiors, sends me over, says, hey, I got something for you to look at, and sends me a copy of a check made out to my guy and says, there you go. There's a check. They actually paid him. And so my heart, there's that moment where you're like, oh my God.
Yeah, exactly.
2 years into this, and did he just forget that he got paid? Like what? And so I call him and I said, Richard, I'm looking at this check. And he said, Natalie, I've never seen that check before. I never got that check. I've never seen it before. And I said, well, it's dated and, it's been run through a bank somewhere. And he says, I'm telling you. And so the check was written out to him, and on the back, it was endorsed. And then there was a secondary endorsement. And I said, well, this might explain, why you've never seen it. And so I called a GBI. I got in touch with somebody from the GBI as a handwriting expert and sent him the check. And he said, every handwriting on this check is all the same person.
Oh, wow.
So I said, okay, well, that then blew up that, wait a second. So they're writing a check, making it look like it was written to him, but it really was, endorsed, and actually the money was taken somewhere else. So what I think ended up coming out in the trial was that the money that son is telling dad has been paid to Richard ultimately is never making it to Richard.
And being pocketed by son is what is.
Well, we're not gonna make allegations. It's just that it wasn't
allegedly.
It wasn't making it to Richard.
Well,
Coming clean about that. So why stick to he donated it? Why? Well, because I think the argument can be made that it would have meant disclosing some questionable conduct if you say, oh, we really haven't paid him.
Right.
So, yeah.
And then I don't know if you want to tie this in, but one of the things that we have is this article about the mayor that was in 2012. So 2 years later, where he got indicted on 12 counts of credit card transaction fraud. And so I guess without defaming anybody, was there allegations that he was basically just stealing money from the city?
I think that was that we were made the argument that there was some kind of malfeasance happening financially with the city, and that the attempt to cover that up was part of what had led to Richard being arrested in order to keep that going. That there's to muddy the waters to keep that from being disclosed. I think that was the jury clearly could understand that might be what was happening. But yes, and then ultimately, you're right, because his indictment and I think his arrest had come out right before the trial, but or either right after. I'm trying to remember, but I know that the jury did not know about that, so they didn't know about any of that. That was all kept out, or any kind of investigation as to the credit card fraud was all kept out. But it was one of those things where it just all looked bad enough that it seemed like there was more at play here than just, folks getting mad at each other, some kind of vendetta, right? Right. It was more than that. But it took us a long time. And it wasn't until the handwriting and we finally got the check, which was funny because that was what was sent to us, I think, to, say, hey, you don't have a case anymore. Right. But that ended up being, I think, what made the case what it was right. that it handed that to us. Right. So once we had that, it was like, well, there's no question now. Once you have the handwriting analysis guy going to come testify that all of it. And then when we got to trial, then they admitted that it was all of their handwriting.
Oh my God. Wait, so I didn't realize that. So what did he say about the check, that he had done it all on his own?
Yeah, so he said that he had done it. He said that Richard had given him permission to endorse it, and then he met Richard and gave him the cash.
Oh,
and he endorsed it over to himself and gave it the cash. So that way, we didn't need the handwriting expert to come in because he had said, "Oh yeah, I wrote it all, but I did it with permission."
oh
So-
my God. Oh my gosh. So I did. Wow. So I guess related to that. So did you end up calling, what did you do at trial other than the stuff that we've already talked about? Did you call the Fennells on cross? Did you wait to see if they called them? How did that all play out? Sounds exciting.
Yeah, I think we did call them on cross. I'm trying to remember. We did it all in a week. So we picked a jury and did everything and was done by Friday. I think we had it Monday to Friday, and we had a verdict. But yeah, I think that's what it was, is that we ended up calling the mayor, and who I still think was one of my favorite witnesses, because she's just the sweetest lady. Her name is Pat Vaughn. And
So this is the mayor.
Powder Springs.
Okay, gotcha.
Yeah.
Right. Who
Powder Springs mayor.
gave the new title out after being told by Walter Williams. Yeah.
And,
Okay.
and she's coming in there and saying, and I said to her, I remember asking her, if they would have told you that there was any kind of dispute, would you have ever issued another title? And she said, well, of course not. If there's any kind of, no, absolutely not. And she was just so believable, because there was no question in the world that this wonderful lady was never going to issue another title. And so that once that, I even think the jury was mad about that, right? That someone's inducing this sweet lady, this wonderful lady, this
Right.
mayor trying to do the right thing, inducing her into this, right? And yeah, so it was a very quick, and then, looking back, I think my opening was, I don't know that I would do it the same way, but trying to lay out these complicated fact pattern cases, which, they seem to be always attached to cases with good results sometimes, is that there is this complicated fact pattern, and you worry about explaining it to everybody or just get too convoluted. And how do you keep it simple enough that people actually can follow it? And that part was hard, keeping all the players in line, and then trying to give some rationale for why the heck would you do this? So that was that we were trying a lot of things there that I had not had to try before, and meaning in terms of ways to make these arguments. But I think in some of these cases where it's small towns, that's the only way to do it.
Yeah, I did think. Yeah, I thought your opening was great. I mean, I wish I could have kept it simple, trying to introduce the facts on our episode, because I thought you did a great job of laying out something that was actually really kind of complicated and weird, and making it seem very simple, especially considering you hadn't tried really any cases as lead counsel at that point. Do you remember what you did, how you worked on simplifying it so that you knew it was going to get across?
I think, I started doing this then. I think I remember starting doing this then and have kept doing it before. And we've all gone to CLEs. We've heard this, if I can't explain the case to my mom in 30 minutes, right?
Yeah.
And her understand it, then I'm doing something wrong. Like, I literally have to be able to take, hey, this is what happened, and cut it down into that succinct and some people would say shorter amount of time. Mm-hmm. And, it's just thinking about, well, what's this really about? What's the case really about? And if what is it really about in terms of, this is about, this idea that they were using their power in a way that they shouldn't use their power, and doing it in a brazen way. And here's why. And then you put in the facts that you need to prop up that theory, your theory of the case. And you don't need every single fact in your opening to do that. But if you can kind of give the sense of, this is really what happened. And you guys know this, you have to be very careful, because whatever you tell them that they're going to hear, that you got to make sure they believe it.
That's right.
I mean, the goal is to be the person in the room who the jury believes as much as anybody. I mean, I want them to like me more than they like the judge. I do. I want them, and I can't do that if they feel like I'm overreaching or I'm being too grandiose in my characterization of anything. And they also can't think that if I'm going too soft either. And so if I get mad about something or I'm irritated about something that a witness says, I don't really hide that. I let that be known. If I think something that somebody says is funny, I laugh. And I think jurors respond to that, or they have.
Yeah,
I agree. I think, I agree. I think jurors respond to being a real person, that you're a human that, sometimes makes mistakes, but you do the best you can. And, I think they like that. We've heard this a lot, and I guess you made it sort of a theme, which is that, this sort of set of facts before your client was arrested was told to a number of people, and they all, came back and said, well, it's a civil matter. And if the mayor of Powder Springs had been told what happened, she would have just said, no, this is a civil matter. You guys go deal with it. And I guess what I'm trying to figure out is when law enforcement says this is a civil matter, to me, they're saying it's not criminal. But they don't want to say it's not criminal. That's like sort of their way of saying it's not criminal. Deal with it at civil court. You guys have a disagreement, but we're not going to arrest anybody over it.
Right. And I think that idea, and, as I've watched the cases that we've all been seeing, play out, this idea of what a massive amount, what an honor it is to be a police officer, what an honor it is to have that power, and how much, especially the vast majority of them are doing such an amazing thing to try to act, to protect folks. When there are the folks who take advantage of that or push past the bounds of what's appropriate with that on any level, that it is more important than anything to have a jury be willing to regulate that. Because if you don't, I think it then has the possibility of diminishing how wonderful what good police officers do every day is. If you don't protect even them from the bad actors, you're doing the good cops a disservice. And that is one of the reasons why I've always felt like these cases, and I've talked to police officers before in cases where they've been witnesses or something, and they don't say it out loud necessarily to you on the record, but afterwards they'll say, oh yeah, go get him.
Right.
Nobody hates a bad cop more than good cops. Right.
That's right.
Yeah.
Natalie, so related to that, one of the things, I don't know if you saw it, I know it's been a while, that I think Bill might have done this in the first part of the close. He talked kind of a little bit about, the sort of historical roots. The historical roots of jury responsibility and of 1983 claims and the Constitution and, protection against false arrest and things like that. And I always love that part but I wonder how much of it is because I'm a lawyer and I went to law school. So I'm wondering if you do that in your cases, in your false arrest cases, or how you think that plays with the jury, how you like to handle that.
I love that. I love that he does that. I had not heard him do that before. I've since heard him do that and watched him do that on multiple occasions in other trials, always with a verdict behind it afterwards, always with a verdict for the plaintiffs. That history aspect of it and really explaining why do we have this cause of action? What's the point? How did it begin? I loved that. I think juries, crave that meaning. They want to feel like what they're doing there is meaningful. And if you can connect the almost historic aspect of why it is that we have this, why is it that these things are put before a jury and what's the backstory of the history of it, I think they loved it. They loved it in that trial for sure. And it may have been because it was part of the political time, what was going on. But I think that's really effective because I feel like you get the verdict that they gave was a message, right? I mean, that I still think, and as far as I know, it's still the highest false arrest verdict against a city in Georgia. And, for a straight false arrest, right? Where you don't have excessive force, you don't have anybody who's shot, you just have somebody sitting in jail for, 8 hours, 10 hours. But I think it's because they were looking at it from the broader aspect of what are we really protecting, right? What are we're protecting, all of us. But I think that was really effective.
Yeah, because I always love stuff like that. Anyway, sorry, Steve.
No, I was just going to ask one thing that Bill referred to in his close, and since we hadn't read the testimony, I wasn't quite understanding. What was the defense saying about this bill of sale? And they were saying they were protecting some security interest or something like that. As Bill sort of went off on that, I just couldn't. Were they saying there was something about the bill of sale that the defense must have brought up, and I couldn't follow exactly what they had, what their defense was there.
I'm trying to remember. I think there was a secondary document where the argument is that they were made the argument that they were protecting the interest in the property, the city's interest in the property, that they had to swear out a warrant because there was a dispute about had he been paid or not. I mean, there was some kind of, that this was an act of us trying to make sure that the car didn't get, was not lost to the extent there was a dispute. I mean, the defense attorneys on the other side, I'm not shy about saying this, are some of the best there are. And King Askew and Mark Webb did a wonderful job. I mean, they threw things at us that we'd not even, as happens, that we'd never even thought about. We're going, oh gosh, never even thought about that.
Yeah.
And it's so hard not to get distracted by any of that, especially when you're, trying a case against people that are your mentors or looked up to in some way or another. And just to try to stay focused on exactly what it is. But, you end up having to knock down some of that stuff in closing. It seems like every single time. So, yes.
Well, and you've touched on this, and I want to make sure the compensatory part of the verdict that was, as Yvonne said, $560,000. Yeah, I mean, and I'm not trying to belittle what happened to your client at all, but he basically spent a few hours in jail. Talk about how you presented the compensatory part of the verdict to get a verdict like that when we're talking about a relatively short amount of time.
I think that's where the small town aspect of the case really ended up, I think, adding value from a compensatory standpoint, is that you've got the, and I touched on this some, I think, in my closing when I was talking about the punitives, but this idea about what's the value of your name, if you've got this tainted part of you, or as far as he's the guy that got arrested. A lot of folks just know that, he got arrested for something in a small town. And, there was all of the police officers had heard about it. And a lot of them didn't know the backstory. They just know, I know Richard, he got arrested for stealing something from the city. And that, there had been 2+ years. We had testimony about how much money that he had not made that he would have made in security work that he had lost out on. And so the compensatory damage was both from, this is lost income. And we couldn't prove it in the traditional way because it wasn't every year his security work would vary, right? It would be, part-time here. But we could show on like a W-2 how much it had gone down from one year to the next. And so he had a dramatic fall off in income because with that sitting there, he was having a hard time. Anybody that would run his criminal history would see the arrest.
Yeah.
And so that, I think, really was how they justified that number from a compensatory standpoint. The punitive part, and y'all may notice that I didn't give them a number.
Okay,
I didn't ask for a number in the punitives. I think Bill asked for 250 in the compensatory part. And we talked about that. Like, do we even give them a number and the punitives? Because they were very sensitive about not overreaching. And I questioned that beforehand. I did not question it after. I mean, afterwards, I'm like, oh my gosh, I'm so glad I didn't give them a number for the punitives.
Yeah.
But we did sort of, I squeezed hard on that about, the name's the first thing you get. It's the last thing you have, tombstone. And so from a reputational standpoint, what could be more valuable to anybody than how the world, what the world thinks about them as far as their character is concerned.
Right.
So,
yeah.
Well, and you also didn't bifurcate, right? So you didn't have the benefit of knowing what their compensatory award would be when you talked about punitive damages.
Right. But there was also, but because we were basically suing for the folks with these assets, I didn't want to bifurcate it because I didn't know what they would ultimately be able to show that they had or didn't have.
Right.
Right.
So,
Yeah.
if you bifurcate it and there's nothing but, 3 or 4 of the buildings and what are you going to, I think that would then dilute your punitive claim.
Right.
Yeah, absolutely. Well, I mean, I guess I say that just to say, they ended up, more than doubling what Bill had kind of asked for in compensatory. So you were on the right track, but you had no way of knowing it at the time. Right.
I know. So better to be lucky, I guess.
Yeah.
For sure.
So were you able to talk to the jury afterwards? And I mean, they basically evened you out right at $1 million. So somebody, had that number in their head. Did they talk to you about how they came up with that or what they thought of the case?
No, it was funny because they didn't want to talk about it afterwards. They were very, very quiet about that. Everybody left. They didn't want to talk about it. It was on the news. I actually ended up, someone, I think years later told me they had talked to a juror and known a juror that had been in the case. And it was a fast verdict. So they were only out. You guys can know what this is like. I mean, they were only out for, I want to say, less than an hour and a half.
Oh, yeah. That makes you nervous. Yeah.
Oh man. So that, we saw that light go on fast and I'm like, oh man. And, so they were not, I think they had, as we now know, all of us know, jurors oftentimes get their minds made up fast. They were where they're going to be. By the time you're not convincing a lot of folks at closing, despite how much we like to think that.
Yeah. I always tell people, closings are fun to do because you get to argue, but I think openings are much more important. I mean, that's where you set the stage and that's where you're painting the picture,
Yeah. I don't want to be having to convince anybody. If I'm having to convince anybody to go my way at closing, I've done something wrong.
Yeah. Oh yeah.
Right. I mean, I think you can try to help them how much they're going to give you, but you don't want to be trying to convince them who's right or who's wrong in closings.
Right.
Yep. Yeah.
Oh, so true. It just makes me think, my palms just started sweating thinking about, it's been so long, but that feeling of both during opening and close, which I have not given to a jury before, but when you're on a trial team and that's happening, just how much I find that such torture, like looking at their faces and just wondering if they're getting it and what they're really thinking. But it's been so long.
Yeah. And it was one of those where, we hadn't spent, it's not like we'd spent millions on the case. This was important for him. It was important for us, but he had, gotten for sure his day in court. And so, I'm sitting there thinking, whatever happens, we've done our best and everybody's going to live to go fight another day. That's harder in cases where you've got catastrophic injuries. We all know that.
Yeah.
There's an emotional component in those kinds of cases. That's different than when the plaintiff is actually sitting right there next to you. He was going to go on vacation with his kids the next week, no matter what happened.
Right.
Right.
So that takes a little bit of that chest feeling that we all get. That makes it a little bit different when you know, hey, they're all walking out of here.
Yeah.
No matter what.
Yeah. Well, it was a great result. And I mean, he's lucky to have found you and to have found you early enough to kind of make sure that you set this up. Because I actually didn't know although it's logical, I've never done a false arrest case. So I didn't really know that you could, just to sort stuff out in the criminal proceedings, that you could actually end up screwing up your false arrest case. I mean, it does make sense, but
yeah.
Yeah. And I mean, there's so many cases that I've turned down over the years. I had to turn down because of that rationale. And, there's arguments to be made, but that you get a call and something bad happened. And you're like, yeah, but they pled guilty to something else, right? Secondarily. And, it's like, well, if you got arrested and you were guilty of for any reason, right. It doesn't even matter what you got arrested for. Yeah, it's not wrongful arrest. So, and that's hard because that ends up being that they've got to then plead not guilty and follow that all the way out, right? Yeah. Or either can get the folks to decline to prosecute. So that part ends up washing away what is probably a lot of otherwise valid false arrest cases.
Yeah. If
they plead guilty to anything. And there's folks that plead guilty all the time just because they don't want to take the risk of going to trial, even if they didn't do it. Right.
Right. Yeah. Yeah, absolutely.
So you take the plea, even if you weren't there, right? Versus facing, mandatory minimums of, 10, 20, 30 years. So mandatory minimums, I think, are a great reducer of false arrest cases because they end up causing folks to plea out versus take the risk of getting a mandatory minimum sentence.
Yeah, so. Absolutely. Well, Natalie, thank you so much for spending time talking with us. I want to make sure, is there anything that you haven't talked about the Lucas versus City of Braswell case that you want to make sure that our listeners know?
No, I mean, I thought about it the other day, the coolest part of that case at the end of it, and some of y'all know Bob Brinson up at Brinson, Askew and Berry. So the courthouse is literally, right across the street really from the firm. And when it was all over, we all went back to the firm and had a drink at the firm, because it was, everybody had, it was just that sense of lawyer camaraderie that I was raised in as a lawyer world. And that was really cool. Really cool. Yeah. So, it was fun for sure.
Yeah, no, that's definitely one of the great things, and I feel like it's been lost, in many cases where you. Me
too. I wish we could get back to more of that, where everybody, still likes each other after it's over.
Right, exactly.
That's the goal, anyway.
Yeah.
Well, Natalie, thank you so much for your time. We really appreciate it. Let me remind everybody, we've been talking with Natalie Woodward of Champ Jordan Woodward in Atlanta, Georgia. And if you want to look up Natalie, you can go to sjwtriallaw.com. Natalie, thank you so much for your time.
Thank you, guys.
Ladies and gentlemen of the jury, have you reached a verdict?
Thank you for listening to the Great Trials Podcast. You can visit us online at greattrialspodcast.com. We realize in the show that sometimes we use terminology that not everybody would be familiar with, or that we haven't always explained every part of the jury trial process. So we've done 2 special shows, one on legal terminology, and Yvonne, that's going to be hopefully not that boring. We've included a number of people in that so that we can make that more entertaining, and a show on the jury trial process. And we've also put links to those episodes on our greattrialspodcast.com, as well as a glossary of the legal terminology on the website.
Yeah, so check those out. If you have a trial you would like to be featured on the Great Trials Podcast, or if you're a trial lawyer and you want to be on the show, or if you're just a person who has something that you want to say to us, please email us at info@greattrialspodcast.com. Note, if you have something mean to say, we don't have email.
Right, exactly. We only need positive commentary.
Yeah, we're fragile. Yeah. You can also rate or review us wherever you get your podcasts, Apple Podcasts, Stitcher, Spotify, Google Play, or wherever. Again, if you have something mean to say, our podcast is not available for review.
We also want to thank the people behind the scenes. One is Taras Misher, who is our podcast extraordinaire. He is from Podcast on the Go, and Allison Hirsch,